Court is not an open mic night. Why you can't raise whatever you want at a Utah divorce hearing. A divorce hearing feels like the moment when everything should finally come out. You're standing in front of a judge, after all, or commissioner, under oath or affirmation, and it's natural to think this is the time to explain everything that's wrong. But that instinct, however human, is legally misplaced. A hearing is not a free-form airing of grievances. It's about a specific request for relief that was teed up in advance. Judges aren't roaming problem solvers. They're constrained decision makers, bound by the notice of the question, the procedure, and fairness to both sides. Raising new issues at court on the fly isn't just frowned upon, it undermines due process by denying the other side a chance to prepare and respond. That's why statements like, "I didn't include this in my motion, but," usually go nowhere. Something can matter deeply and still be off limits at that moment. Relevance isn't the same thing as procedural availability. Courts cut people off not because they don't care, but because structure is what keeps the system fair and workable. The right way to be heard is almost always preparation, the correct motion, proper notice, admissible evidence, and clear framing. Improvisation feels cathartic, but discipline is what actually gets results. Hearings aren't improv, and they're not open mic nights. If you want the court to decide something, you have to ask properly, in writing, before you walk into the room, ordinarily.